Good morning. My name is Krishna Jha from Softwarica College and IT E-commerce. I am presenting as a cybersecurity consultant for my module, The Ethics and Legal Framework of Cybersecurity. My presentation is titled Employee Data Leakage and Whistleblowing, Cybersecurity Legal and Ethical Case Analysis. I have been engaged as a cybersecurity consultant for my multinational organization facing a serious crisis and employee leaked sensitive customer data to an external third party. This incident raises critical questions: what cybersecurity ethical are at stake? How do data protection laws apply? Does this action qualify as protected whistleblowing? And what governance failures allowed this to happen? My objective is to evaluate this incident from both legal and ethical perspectives and provide clear, actionable professional recommendations. A multinational organization experienced a major security incident when an employee leaked sensitive customer data to a third party. From the employee's perspective, the disclosure was necessary to expose corporate malpractice. It qualifies as whistleblowing, and the public interest justified the breach of confidentiality. From the organization perspective, the employees violated confidentiality agreement, compromised customer privacy, breached internal policies, and violated data protection law, including GDPR and Data Protection Act 2018. The central question of my entire analysis is this: was the employee action ethically justified, legal protected, both or neither? I will answer this systematically. This case demonstrates a fundamental conflict cybersecurity professionals face regularly. On one side, we have a duty to protect the public interest by exposing wrongdoing. On the other hand, we have an equal duty to protect personal data that customers trust us with. The key issues include privacy, confidentiality, responsible disclosure, regulatory compliance, and corporate accountability. This case provides a framework for navigating the difficult territory. Before evaluating the customer's actions, I must establish the relevant legal framework. There are four key laws. First, there is GDPR 2018. This governs personal data processing for European citizens. Article 5 and 32 mandate lawful, fair, transparent, and secure data handling. Second, the Data Protection Act 2018. This is UK's implementation of GDPR and criminalizes unauthorized data disclosure in certain circumstances. Third, the Computer Misuse Act 1990. This prohibits unauthorized access to computer system and data, including accessing data for purposes beyond one's authorized job role. Fourth, the Public Interest Disclosure Act 1998 or PIDA. This protects whistleblowers but critically requires internal disclosure or disclosure to a regulator. Public disclosure is legally protected. Let me conduct a detailed GDPR analysis as this is where the employee faces the most significant legal exposure. First, lawfulness, fairness, and transparency under Article 5. The employee shared customer data without any valid legal reasons. No authorization, no customer consent, no legal exception. This is a direct violation. Second, integrity and confidentiality. Under Article 5, once the data left the organization system, the employee lost all ability to protect it. The data could have been copied, sold, or misused in ways entirely beyond the employee's control. Third, security of processing under Article 32. This piece provides organization security measures were inaccurate. A poorly designed system would have prevented bulk data extraction without detection. Finally, the consequences: the organization faces fines up to 20 million euros or 4% of global annual turnover. Beyond financial penalties, there is reputational damage and potential criminal prosecution for the employee. Let me consolidate the key legal findings. Under GDPR Article 5, the data was disclosed beyond its intended purpose, breaching confidentiality, accountability, and purpose limitation principle. Under the Data Protection Act 2018, this is reportable personal data breach. The organization must notify the information commissioner's officer within 72 hours of becoming aware of the breach. Under the Computer Misuse Act 1990, even if the employees had authorized access for their job, using the access to extract data for an unauthorized purpose can constitute a criminal offense. UK courts have upheld this interpretation in multiple cases. And finally, breach of confidentiality. The employees violated legally binding non-disclosure agreements and employees contracts. Now I address the employee primary defense whistleblowing. Under the Public Interest Disclosure Act 1998, for legal protection, four conditions must be met. First, the disclosure must be in good faith. Second, the employee must believe the information is true. Third, it must be the public interest for, and the most critically, the employee must use appropriate reporting channels. PIDA establishes a clear hierarchy. Internal disclosure to the employer is most protected. Disclosure to a regulator like the Information Commission officer also protected. Disclosure directly to public or media receives protection only in very narrow circumstances, such as when the employer would destroy evidence or when internal channels have been executed. In this case, the employee leaked data directly to third party with no evidence of attempting internal disclosure. First, therefore, protecting under PIDA is not automatic. Courts have consistently ruled that exposing unnecessary customer data weakens or eliminates whistleblowers' protection. The employee's defense is legally weak. Now I evaluate whether the employee's action were morally justified. I apply two major ethical frameworks. First, utilitarianism. Associated with Gemini Benetham, this evaluates action based on consequences, the greatest goods for greatest number. The potential benefit is exposing corporate malware. However, the harms are significant. Innocent customers had their private data exposed without consent. Organization trust was damaged. Massive financial penalties may impact jobs, and a dangerous precedent is set. Unless the malpractice involves imminent risk of death or serious physical harm, the harm is innocent customer outrage. The public benefits. Utilitarianism gives a mixed verdict, leaning negative. Second, deontological ethics associated with Immanuel Kant. This evaluates action based on duties and rules, not consequences. The employees violated multiple rules: confidentiality to customers, following the law, earning contacts, and professional conduct standards. Kant's critical imperatives requires that we act only according to rules that could be universally applied. If every employee who believed their customer was acting wrongly leaked customer data, no organization could maintain the security. This principle cannot be universalized. To summarize, utilitarianism gives a general negative verdict. Deontological ethics gives a clear negative verdict. The employee's actions are not ethically justified under either framework. However, I would be providing an incomplete analysis if I placed all responsibility on the employee. The organization has unethical failures. First, no safe reporting channels. Second, poor transparency. Third, weak accountability culture without ethical leadership from the top. Employees feel unheard and powerless. This is systematic failure. The organization must accept its share of responsibility for creating the conditions that made this incident more likely. Based on my complete analysis, here is my professional recommendation. The employees fled five professional responsibility: integrity, confidentiality, accountability, professional competence, and responsible disclosure. My overall verdict: the employee's action was illegal under GDPR, the Data Protection Act, the Computer Misuse Act, and PIDA. The action was ethically unjustified under both deontological ethics and utilitarianism. However, organization failures contributed significantly. Prevention requires both individual accountability and systematic reform. My five recommendations as follows: 1. Implement an anonymous whistleblowing hotline so employees have a safe legal way to report concerns. Second is provide mandatory cybersecurity ethics training. Third one is enforce data access controls using principle of least privilege. And fourth one is establish a clear incident reporting policy so every employee knows exactly what to do and whom to contact. And last one is to develop an ethical leadership and governance framework. Accountability must start and top. Let me deliver my final verdict. The employer's intention may have been ethically motivated. However, good intentions do not change legal reality and do not override professional ethical duties. Legally, the action is unlawful. The employer violated GDPR, the Data Protection Act confidentiality agreement, and did not use proper PIDA channels. My final verdict: the employee's action is both legally unlawful and ethically unjustifiable. However, the organization must implement urgent systematic reforms. The absence of safe reporting channels, poor transparency, and weak accountability culture all contributed to this incident. The final lesson for every cybersecurity professionals: we are guardians of data. We must always choose responsible disclosure through proper channels over unauthorized public leakage, no matter how justified we personally feel. My references include General Data Protection Regulation GDPR 2016 679, Data Protection Act 2018, Public Interest Disclosure Act 1998, Computer Misuse Act 1990, Individual Privacy Act 2080, Information Security Management Standard, mention principle of utilitarianism, can the groundwork of metaphysics of morals. Thank you for your attention. This concludes my presentation. I am Krishna Jha.